You're welcome to Let's Talk.
We should sit down and talk. We need to sit down and talk. How Nigeria should go, how we're going to do our job.
If one can stand up and say no to corruption, we're going to do our job, protecting the system. You are not just doing good for yourself or for the nation alone, you also do good for the future.
Boko Haram is an attack, it's a spiritual attack. It's a satanic attack on Nigeria. We must, if we come to recognize it, we will understand then how to look for the solution.
A sovereign national conference, how do we want to achieve that in our present system? We need to sit down and iron out how Nigeria should be governed.
Hello and thanks for joining us on another episode of Let's Talk. Now, one of the main things, the main stories that is in the news in Nigeria is the seeming saga of the bribery and counter-bribery allegations that is rocking the House of Representatives fuel subsidy probe. The main actors that we have in this drama still are the lawmaker and head of the probe report, that is Farouk, Lawan, as well as the oil magnate Femi Otedola. And Nigerians are asking, watching on some with dismay, what is going to happen? Why aren't we seeing any prosecutions going on? A lot of speculations going on within this context. But today we want to look at the legal perspectives on the Farouk Lawan bribery allegation. Now, people are wondering, why are things not happening faster? We want to see people being prosecuted. But could it be that because of a legal process, we are not seeing things happen as fast as we would like to see them happen? And you know, the law is a wonderful thing. You know, no one is, everyone is presumed innocent until they're proven to be guilty. So today we're going to be looking at the legal perspectives on the Farouk Lawan bribery allegation, perhaps to help us better understand why things are going the way they are going at the moment. All right, and I'm pleased to inform you that I am joined this morning by Chris Akiri. He is a legal practitioner, consultant, excuse me please, a consultant, a social expert, and a public policy analyst. You're welcome to Let's Talk.
My pleasure.
Okay, so first of all, before we proceed, you know, every day we see new things happen in the news. You know, things keep unfolding. Lately, we saw some audio recordings being released of conversations alleged to be between Farouk Lawan and the oil magnate, and a lot of things have happened. We saw Femi Otedola being summoned by the House of Representatives, and him saying that he's not going to answer any questions unless it's made public, and all of that. What's your reaction? You know, as these things keep unfolding every day, what has your been reaction so far on the entire saga?
Well, I think you used a very opposite word when you said seamy saga. It is indeed very seamy, and it is terrible, it is unfortunate, it is nauseating, to put it very mildly. Here is a crime situation, you know. Somebody has been alleged to have committed a crime. Now, what do we do when somebody is alleged to have committed a crime? Like you correctly stated, Chapter 4 of the Constitution of the Federal Republic of Nigeria, 1999, says every person, every accused person is deemed to be innocent until proved guilty. Yeah, we know, but you have to prove the person guilty or not guilty by prosecuting the person. If you don't prosecute the person, you don't try the person in the National Assembly, you don't try the person in a shop or on the streets, you try the person in the court. The person has to go to court. People have to piece together pieces of evidence, snippets of evidence, to prove the guilt or the innocence of that person. But none of this is being done. Okay. Now, to start with, the oil magnate, Femi Otedola, alleged that Farouk Lawan, the chairman of the probe panel, collected $620,000. He personally collected $500,000, and his own aide collected $20,000, bringing the whole thing to $620,000. Is this true or not? Now, this is what has to be established. Now, at first, this person said, Farouk Lawan said, no, I didn't collect a couple from this person. No, it's just a liar. I didn't collect anything. If he has any tape, it must have been doctored. Just the same way as the Obasanjo tape was doctored in the Abacha era. So I didn't collect any couple. 2 days later, he said, yes, I collected. I collected $500,000. But I collected it to expose him.
Okay.
All right. Now, later, you decided, but if you collected it, then you collected a bribe. No, I didn't collect a bribe. I collected money. I collected money, but not bribe.
What's the difference?
Oh, yes. I collected money, but not bribe. Now, on the part of Femi Otedola, he said that the money that he gave was marked. Now, and that he gave out the money in a sting operation.
Okay.
Now, let us examine that to start with. If you gave out the money, if you gave out marked money in a sting operation, marked money is, you put some powdery something on the money so that whoever collects it, you will see it in the hand as soon as he has collected it and he has put it in his pocket or wherever, or in his hat or wherever, then the police will arrest him and then say so. Why was this person not arrested? You did that with the knowledge of the police. That's the meaning of marked money.
Yeah.
Marked money means the moment that money is given, the person will be arrested. So why was he not arrested? Why was this matter kept in the cooler until after 6 weeks or almost 2 months before it came out? So how would you know that person, thank God this person agreed that he collected $620,000. Or why was the person not arrested? So the police have to talk. Okay. They are keeping mum, and they should never keep mum over this matter.
Who really is supposed to instigate legal proceedings against these? Is it the police? Is it the federal government?
The police or the Attorney General of the Federation.
Okay.
It's the duty of either of them, even if you bring in the ICPC or the EFCC to do this, they still have to go through the police. They still have to go through the police, go to court. But none of the security agencies is ever doing any of these things. And the federal government, the Attorney General of the Federation, is also keeping mum over this matter. The police is keeping mum. Were you aware, if it was a sting operation and you gave out marked money, why was the person who collected this money not arrested the moment he stepped out of the house, out of either Femi Otedola's house or out of any hotel or wherever? Why was he not arrested? Why are we hearing about this matter 6 weeks after the event? All right, so these are some of the things. Now, but that's aside. As far as Farouk Lawan is concerned, thank God he agreed. He collected this money. So what's the police doing? The Criminal Code Act, Cap 77, Laws of the Federation of Nigeria, and the Penal Code Act.
Yeah.
Because you see, there is a dichotomy between the criminal laws governing the south of Nigeria and the north of Nigeria. Here in the south, we are governed by the Criminal Code Act. And in the north, they are governed by the Penal Code Act. All right? Now, both of them say if you give a bribe or you receive bribe, you have committed a crime. So why are the police keeping mum over this matter? Okay. That's what all Nigerians are asking for.
Okay, well, the police, they say they don't have enough evidence to prosecute the lawmaker, saying that, this allegation that the tapes were doctored, that is their own point. So they don't have enough credible evidence to prosecute him.
They should tell that to the Marines. that they don't have enough evidence to prosecute. That is, well, you permit me to use the language, balderdash. How can you say such a thing? That you don't have it? What evidence? In fact, as far as I'm concerned, the tapes mean nothing. I mean, what are the tapes supposed to uncover? They are supposed to show, to reveal to the public that this man collected the money. That he collected money, $620,000 or $520,000. I mean, $500,000. That he collected this money. You know, the process of collecting this money, the conversation that took place, either before, during, or maybe after collecting this money, all of them will be revealed by the tapes. But the man has already accepted. He said he collected the money. So what are the tapes about? Whether that is the voice of Farouk Lawan or not is immaterial, because he has already said he collected the money.
Okay.
So what did you collect the money? You cannot see that there is no need for tape. The tape is to reveal whether he collected the money. You know, in other words, he will be caught. What in law we say in flagrante delicto. When you are doing something, you're trying to do it, you know, surreptitiously so that nobody would see you. Then all of a sudden the camera's on you and then you are caught in the act. That's what we call in flagrante delicto. So he was caught in flagrante delicto.
Okay.
Yeah? If he did not say, if he did not accept, then the tapes would have come in handy. Okay. It is then you would have said, but that's not the voice of Farouk Lawan. Oh no, but that's not the thing. Like some lawyers are beginning to say. I mean, that's not material now. The man has accepted. He collected the money. So what are the police waiting for?
Okay, well, if you're just joining us, we are looking at the legal perspectives on the Farouk Lawan bribery allegation. I'm still talking with Chris Akiri, legal practitioner, consultant, social expert, and public policy analyst. Now, we're still looking at the legal aspects of this. Now, legally, really, what should be expected of the House of Representatives at this juncture? Now, remember, when Farouk Lawan was summoned, he was summoned privately.
Yes.
And when Otedola was also summoned, he insisted that it should be made public.
Yes.
Now, within the confines of the law,
yes,
was that the right thing to do? Was the hearing supposed to have been conducted in closed session?
Yes. What the House of Representatives, you see, the role that the House of Representatives is trying to play is odious. I don't think they are playing it right. They hinge all their actions on the provisions, on the powers conferred on them by the provisions of sections 88 and 89 of the Constitution. Yes, they have the right to probe into certain things, to investigate. Now, when they investigate, then the result of the investigation will be made available to the security agencies. It's not as if they can try any case.
Okay.
The way they were trying to do. They cannot try any matter because then they will be usurping the functions of the judiciary. They can't try. They can only investigate, summon people, and if the person summoned is refusing to come, they can issue a bench warrant, they can subpoena the person to come. They have the right to do that under the provisions of sections 88 and 89 of the Constitution. But that is the end.
Yeah. But
now, so the question you asked is that they can't try. This is a criminal matter. You can't try it in camera.
Okay.
Yes, you can't try it in camera.
Okay.
Otedola was quite right when he insisted on being tried, you know, in the open.
Okay.
I mean, if I were, that's the same thing I would have done. Try, okay, let the whole world hear.
No, see what's going
Although
on.
Otedola has his own problems,
Yeah.
because if he was trying to play the role of, you see, there is an expression in French which is woven into law today. I mean, it's there. Any lawyer knows it. We call it an agent provocateur. An agent provocateur is somebody, an official, who has gone to another person to let that person commit an offense that he wishes to commit, but nobody knows he's trying to commit that offense already. Okay. But an official is sent to that person, much as was done during the time of a former chief of general staff in this country, during the reign of one military dictator, and then the chief of army staff was sent to this chief of general staff to go and bring him in or rope him into an offense. You know, then went to him and then said, Oga, we are tired of this man called head of state, this dictator. I mean, what's it all about? I mean, we are just afraid of you. We are just afraid of all the lower officers are saying they are afraid of you, otherwise they would have taken action against this man. The man said, is that what you mean? And all that, until they roped him in, until he issued a check to, you know, to give to people who would topple that government, and he was arrested. Now, the chief of army staff who went to put that person into trouble is called an agent provocateur. Now, the victim, who was the chief of general staff, could have a defense, and that defense is called entrapment. Entrapment meaning, I didn't want to commit any offense before, but this person came to rope me in. But it's hardly any offense. I mean, hardly any good defense. Because if you did not want to commit the offense, the person came to rope you in and you fell into it, then you are a criminal. So either Otedola was an agent provocateur or he was not. If he was, then it should be true that he gave marked money to Farouk Lawan. Now, but if he gave marked money to Farouk Lawan in a sting operation, why was Farouk Lawan not arrested immediately? In other words, I see both parties, that is, both the giver and the taker, as being in for serious trouble. They should both be prosecuted, and they should go to court and prove their innocence.
Okay, now Otedola himself has not really been able to release the purported video of the bribe allegations between Farouk Lawan and himself. So do you think that the whole thing is really just a hoax to kind of divert Nigerians' attention from the main issue, which really is the report and the findings and the recommendations of that report, which were not being seen being implemented? We're not seeing those recommendations being implemented. Yes,
I think some people may be behind. That's why I say both parties, including Otedola himself, must be prosecuted. You know, because somebody or a group of people must have used Femi Otedola to do this job in order to cast some doubt or serious doubt on the report itself. Which, as far as I'm concerned, because almost every person is saying, no, go on and act on the report. But I don't think it is proper to act on that report the way it is. Everybody said, no, you cannot throw that report into the dustbin. Yes, they may be right, but I don't think you can use that report in the court. Because you see, the report is already tainted by all these revelations. The report is already tainted. And the admissibility of that report in evidence becomes a problem. You see, when you use that report, all those indicted people will wriggle out of the whole thing. When you get to court, smart lawyers are going to say, are you basing the indictment of my client on this tainted report? And then the judge will be listening. You see, at the end of the day, the matter will be thrown overboard because the report is tainted and it may not be admissible in evidence. And that's why I think something, you know, a kind of verification committee must be put up, must be put up to look into the report and investigate the report, whether it's right or wrong, because, you know, Femi Otedola's name was formally, it was there, it was inside the report. After the gift of $620,000, this man went to the open, you know, plenary session of the House of Representatives to move a motion that, well, let a particular name or two names be removed from that report, and the names were removed. So who knows whether some people, and Otedola alleged that those people who could not pay had their names there, but those people who paid had their names removed. So that type of report. You see what I'm talking about.
Okay, well, the President Goodluck Jonathan, has expressed willingness to implement the recommendations, although you are now explaining that it would not be proper to base any indictments on the recommendations alone, seeing that they're already being tainted. Now, there was an injunction by Integrated Oil and Gas Limited asking the federal government to halt the implementation. You know, now does that have any bearing? Do they have the power to do that, to actually ask the federal government not to implement any of the recommendations in that report,
Yes,
from a legal perspective?
Yeah, I answered that question in the affirmative.
Okay.
Yes, the court has that power and more powers to stop action on that report.
Okay.
But that is as far as this integrated oil and gas company is concerned.
Okay.
Yes. If the president wants, if the government wants to act on the report, irrespective of all the other indicted people, he could go ahead. The government can go ahead, but not as far as this oil and gas company is integrated oil and gas company is concerned. That's all. Now, so that's a major. But I'm saying that, my advice is that they should not act on this report the way it is. Okay. They should have a verification exercise, to prove that this report is actually the way that it could be acted on and could be admissible in evidence.
Okay, but the history that we have had also with committees and panels. We see the way they go. We have a lot of panels being set up, and they always seem to have controversial endings. One thing or the other seems to come in, and we're not seeing results. Now, what really should, from a legal perspective, and that is the last question, if the federal government, and if Mr. President, like he said he was, is sincere in ensuring that offenders are brought to book, what should happen? What should the legal process be to bring perpetrators or whoever is found guilty in this matter? What should happen? What should be the role of the House of Representatives, being that they were the ones who conducted the probe? Legally, what should happen for this to be, to proceed in a legal manner, in a correct manner, and seeing results?
Now, first of all, I like to state, I want to state categorically that neither past governments nor this one had any political will to stop corruption in this country and to prosecute offenders. There is complete absence of political will to do anything about corruption in this country. I mean, the House of Representatives, the National Assembly, let's put it generally, because the Senate also has its own probe thing. Now, the National Assembly has investigated something, and they've come up with findings. Like I told you, they cannot try indicted people. They can only indict certain people, say this person is an offender. This is the result of our own investigation. Thereafter, they submit the document to security agencies, the police in particular, the EFCC, the ICPC, for action. You see, it doesn't stop there because they can do nothing else after investigation. They submit the document to any of the security agencies for prosecution, or to the AGF, the Attorney General of the Federation, for prosecution, if it's a federal offense. Now, nothing like that is done. And we are so clever. Every Nigerian has a PhD in corrupt practices. The science of corruption. Every person has a PhD in it. So that once any investigation is completed, then the indicted people know what to do in order to forestall, to prevent prosecution, like in this particular case.
Okay, well, we have been looking at the legal perspectives on the Farouk Lawan bribery allegation, and we're not done, analyzing, and we hope to have another opportunity to look into the matter and see really what can be done, what should be done for this to proceed legally. However, the point that has been made really is that it is all about political will. We know what to do, we know what should happen, but do we have the political will to carry through? That is the main question. Well, I have been talking with Chris Akiri, a legal practitioner, a consultant, a social expert, as well as a public policy analyst. Thank you very much for honoring our invitation once again. And thank you also for being part of this edition of Let's Talk. Let's do this again sometime really quick. And thanks for joining us.
You're welcome to Let's Talk.
We need to sit down and talk. We need to sit down and iron out how Nigeria corruption, how we're going to do our job.
If one can stand up and say no to corruption, we're going to do our job, protecting the system. You are not just doing good for yourself or for the nation, you also do good for the future.
Boko Haram is an attack, it's a spiritual attack. It's a satanic attack on Nigeria. We must, if we come to recognize it, we will understand then how to look for the solution.
The sovereign national conference, how do we want to achieve that in our present system? We need to sit down and iron out how Nigeria should be governed.